In one historic and unexpected ruling, the Supreme Court has now made it illegal for an employer to fire someone because of their sexual orientation or gender identity. Now, this is unexpected because the Supreme Court is conservative, yet this was a 6-3 ruling. So let me first show you some of the details here from CBS, and then I'll get into the reasoning of why it was such a major victory here. So the court's 6-3 ruling extends the scope of Title VII of the Civil Rights Act, which bars discrimination on the basis of sex, race, color, national origin, and religion, to include LGBTQ people. Chief Justice John Roberts and Justice Neil Gorsuch, who authored the majority's opinion, joined the liberal wing of the bench in ruling that, quote, an employer who fires an individual merely for being gay or transgender violates Title VII. Quote, judges are not free to overlook plain statutory commands on the strength of nothing more than suppositions about intentions or guesswork about expectations, Gorsuch wrote. In Title VII, Congress adopted broad language making it illegal for an employer to rely on an employee's sex when deciding to fire that employee. We do not hesitate to recognize today a necessary consequence of that legislative choice. An employer who fires an individual merely for being gay or transgender defies the law. So, basically, what this does is extend the rights that everybody else already has to the LGBTQ plus community. Now, the reason why Gorsuch was on board here is because he is what is described as a textualist, meaning that he doesn't take into account what the authors of the Civil Rights Act thought back then in terms of why they were writing that. He looks at it in terms of the text. What does the text say? And now what does that text mean in modern day? So he applies the word sex being in the Civil Rights Act, applies that also to gender identity and to sexual orientation. So they use a couple examples here to make this point. Now, this is the ruling. It is almost 200 pages long, so I haven't read this entire thing, but I have read a bit of it. Let me just give you a little bit here. So the lessons these cases hold are instructive here. First, it is irrelevant what an employer might call its discriminatory practice, how others might label it, or what else might motivate it. In Manhart, the employer might have called its rule a life expectancy adjustment, and in Phillips, the employer could have accurately spoken of its policy as one based on motherhood. So what they're referring to here are two other cases where employers tried to fire somebody, or in the case of life expectancy, they were making female employees pay more towards pension than their male employees because they figured, well, women live longer, so they got to put more into the pension. Well, that ruling was reversed. And in the case of motherhood, an employer fired a woman because she had 2 kids. So even though that is not sex, she wasn't fired because she was a woman, that still applies to the fact that she is a mother. So they're using that same idea here where, you know, while civil rights were written with the intention that, or the idea that sex meant men and women get equal rights, it still applies, just as it applies to motherhood or life expectancy, it applies to what that means in terms of what that now means today in terms of gender identity or in terms of sexual orientation. So this is why you have this sort of ruling, because they were not thinking of this in terms of how it was written back then, but in terms of how the actual text of what Title VII means, how that applies today. So let me also give you the breakdown here of the Supreme Court justices that were against and ones that were for. So against, Samuel Alito, who wrote more than 100 pages in dissent. Brett Kavanaugh, also against. Clarence Thomas, also against. And then for, Neil Gorsuch, as I discussed, John Roberts, Stephen Breyer, Ruth Bader Ginsburg, Sonia Sotomayor, and Elena Kagan. So this, before this ruling, you could actually be fired in 30 states for sexual orientation and gender identity. So there were a number of states that did have already protections on the books, but now this extends civil rights protections across the board nationally. Now, there isn't much else to add here. I mean, this is a fantastic ruling, a rare piece of positive news. At the same time, I don't want people to just think, oh, the Supreme Court now, don't got to worry about it. I mean, look at this ruling. No, when it comes to these very narrow social issues. Occasionally, even a conservative Supreme Court will rule in the humane direction, I guess you could say. But when it comes to most other issues, including abortion rights, it's one you have to worry about down the line. So even in that case, a social issue, you still got to think about it. But in terms of, really when it comes to corporate power, the Supreme Court is almost always going to favor or going to rule in favor of massive corporations and corporate power over everything else, unless it has to do with a social issue like you see here. So fantastic ruling, rare piece of positive news. Let's hope we get some more positive news in the future.